Our next speaker is Dale Orlando. Dale got a law degree from Western, 1994, called to the bar in 1996. Practices with me, just an outstanding lawyer, good guy to have around the office. Dale is going to talk to us about developing theories of liability, again from the outset, and how important that is. There's a lot of material in there. I don't think Dale will get through all of it, but he'll do what I can. Dale?
Thanks, John. If I can get the lights down, I'm going to have a PowerPoint presentation as well. I just want to start off by saying, as everybody knows, there's two aspects to every case, and it certainly doesn't do you any good to finish a 5-week jury trial, get $1 million verdict, and have the jury come back and give you zero liability. So it's obviously very important to be able to establish liability and to be able to recognize good liability facts and recognize bad liability facts. The first step in being able to recognize those facts is having an understanding of the law that applies to your specific case. Now, sometimes it's very clear. I mean, if you've got a garden variety car crash, your guy's in his lane, somebody crosses the center line, you don't have a liability concern. It gets a little bit more difficult when you're looking at road authority cases, for example. Pedestrian knockdown cases can be tricky sometimes, and tavern liability cases. And my paper primarily focuses on the law, the underlying law of liability in each of those areas and the evolution of that law. But before I get to the law, what I'd like to say is, first and foremost, you need your facts. You need to be able to establish your liability facts, and the best way to do that is by early investigation. We, as lawyers, a lot of time don't have the time to follow through and on the leads you get, the early leads that you get from a police department or from, somebody will indicate that there were witnesses. What we're moving more towards in our office is hiring a private investigator to go out and do that in an early initial investigation. This isn't in the paper, but we use Larry Harrington from Albright Investigations, but there's a number of good investigators out there who can go out and meet with the investigating police officer, and you'll be amazed at what's behind that police report and those initial officer's notes. And you can get all of that by way of freedom of information, and you will get it in due course, but it's nice to have somebody get there while the memories are fresh and talk to these people and commit them to a statement in writing if you can do that. The first type of cases that I'm going to talk about are road authority cases. You might be saying, well, what are road authority cases? There's a number of different aspects to those, but I'm going to focus primarily on salt and sand cases because most of the cases that I've come across have dealt with a failure to salt and sand or keep a road in a proper state of repair. Having said salt and sand cases, it's got to be made clear, and this is clear throughout all of the cases, that there is no general duty on a municipality or on a crown to keep a highway with salt and sand or to salt and sand a roadway. There is a statutory obligation on municipalities and on crown authorities to maintain a roadway in a proper state of repair, roadway or bridges. So your target defendants in these types of cases are municipalities if the roadway is one where the municipality is charged with keeping it in a proper state of repair, or if you're dealing with the King's Highway or the 401, you're looking at the Crown. Municipal liability is founded, statutory municipal liability is founded in Section 284, Sub 1 of the Municipal Act, and this is the section that talks about an obligation to keep a highway in a state of repair, and that's qualified by the words that is reasonable in light of all of the circumstances, including the character and location of the roadway or bridge. So as you can see, it's going to be difficult to lay down any hard and fast rules with these types of cases. The cases are going to turn on the specific facts and circumstances, and really to get a good feel for your liability facts, you're going to have to look at some of these cases, and I've laid out a number of them in my paper. Liability of the provincial crown for example, 401, Highway 401, is found in the Public Transportation and Highway Improvement Act, Section 33. And that section states that the Crown shall keep the King's Highway maintained in a proper state of repair and Section 33 sub 2 of that legislation makes the Crown liable for damages sustained as a result of the highway falling into a state of non-repair. The first case, there's a number of cases that precede this one, but this really is I think, the starting point when you're looking at liability cases and the evolution of the law in this area. It's Millette versus Cote. It's a 1976 Supreme Court of Canada case. And again, it confirms that there is no general duty to salt or sand a roadway. And in rejecting the contention that there is a general duty to salt and sand on the part of a municipality or on a Crown, the court seems to impose an additional requirement that there be a special and highly dangerous condition present in order for a municipality or a Crown to be found liable. If you look carefully at the case, it doesn't really say that, but all of the cases that have followed Millette versus Cote have said that you have to have a special and highly dangerous condition in order for there to be found, in order for liability to be found. This is an additional stumbling block or hurdle when you're encountering these types of cases, and it does make these cases tricky, as can be seen by a review of the case law. I mean, in some cases, when I read them, it seemed to me that there should be liability, and those were the cases sometimes where the plaintiff was shut out, and conversely, some other cases where it really didn't seem reasonable that the municipality would have had a chance to get there and take care of the problem. In those cases, there sometimes was liability, so they are tricky cases. Gould versus County of Perth. This case confirms that each case is going to be decided on its fact, and liability will result where the failure to salt or sand within a reasonable period of time creates an unreasonable risk of harm to users of the highway. Again, subjective language, and it's open to interpretation in each case. Now, the earlier cases, like Gould versus County of Perth and the cases that precede it, those cases focus on a number of things. One, the prevailing weather conditions and when the ice or where the black ice or slippery condition would have formed. Secondly, when the municipality or Crown Authority would have become aware of it. And thirdly, the amount of time that elapses between them becoming aware or ought reasonably to have been aware of the condition, and when the accident takes place, and whether it was reasonable that the condition wasn't remedied in the interim. That's the older case law. There's been two recent developments. The first is the Montani case, Montani versus Matthews, and the second is Besokis versus Brampton. Those are two recent Ontario Court of Appeal decisions. And in those cases, the road authority is not alleged to have known about the ice being on the roadway before the accident occurs. But more specifically, what's suggested in those cases is that the road authority was aware of circumstances where the formation of ice or treacherous conditions were a virtual certainty. Now, the first case is Montani versus Matthews. In this case, the bridge in question where the collision takes place was salted and sanded at 8 a.m. on the day of the crash. The bridge was inspected at 11 a.m. and was found to be free of ice. And at 11:30 a.m., a collision took place. But what the court found was, with respect, when looking at the history of the bridge and the character of the bridge and the weather conditions that were prevailing at the time, the formation of black ice was a certainty, and the municipality did nothing to act to attempt to alleviate this condition before it formed. And as a result, the bridge was found to represent a special and highly dangerous condition. Now, that case was followed by de Baratok, Justice Wilkins. He interpreted the Montani case, and he narrowly confines it. He says that case relates specifically to that bridge because it had special characteristics, and all of the circumstances of that case relate only to that case. But the Montani case since has been considered by the Court of Appeal again in 1999 in the Besokis case. And once again, there's no evidence that city officials were aware of ice on the roadway before the collision took place. 2 days before the collision took place, the road had been patrolled, And the day before, salt and sand had been spread on this particular roadway. Moreover, this case is different from Montani in that there was no record or history of this particular patch of roadway being a problem, freezing over, black ice forming. What the court found was that there was no need to have the actual formation of black ice before the collision occurs, the city knowing about the actual formation of black ice before the collision occurring, in order for there to be a finding of non-repair. In this case, it was sufficient to show that the conditions that were prevailing at the time made it extremely likely that black ice would form, and as a result, this represented a special and highly dangerous situation. Now, I said these cases are tricky because of the requirement of a special and highly dangerous situation. They're also difficult for another reason, and that's because the defendants in these cases have open to them the policy defense. What I mean by that is it's open to the defendants to suggest, well, we didn't inspect that section of roadway, or we weren't applying salt and sand to that section of roadway because we had made a policy decision that we weren't going to do that. That was a decision that had to deal with the allocation of scarce resources. And you can't cover every road all the time, so we had made a decision. And it's going to be incumbent upon you to characterize the decision not to properly inspect or not to properly maintain the roadway as an operational decision, not one having to do with policy, but more a decision going to the operational aspects. And this could be the topic of another talk, so I'm going to leave it at that. There is a case cited in my paper, Supreme Court of Canada case, fairly recent one that discusses operational versus policy decisions, and I ask you to read that if you have one of these cases. I've been told I have 5 minutes left, so I'm going to move quickly into commercial host liability cases. And what I can tell you about those cases is that there's two statutory requirements that you should be familiar with. The first is the Liquor License Act, and the second is the Occupiers Liability Act. The Liquor License Act, Section 29 indicates that it strictly prohibits the sale of liquor to an intoxicated person, and Section 39 of the Ontario Act imposes liability against a tavern for damages arising as a result of the sale of liquor to an intoxicated person or a person who was apparently becoming intoxicated through the consumption of liquor. When you're looking at cases in this area, the first case that you start with typically is Jordan House versus Munro. That's a 1974 Supreme Court of Canada decision in which the Jordan House Tavern was found to be 33% responsible for Mr. Munro's damages. Now, Munro was a known drinker and was known to the tavern owners as a person who did have a tendency to get drunk. He had spent 6 hours at the tavern that day drinking and was quite intoxicated and was served past the point of intoxication by the servers. After leaving the bar and he was staggering home, he wandered out into the roadway and was hit by a car and suffered serious injury. And what the court found was that the tavern was statutorily liable pursuant to the Liquor License Act, but moreover it developed a duty of care against the tavern to take reasonable care of patrons entering into the premises, and that duty of care was founded upon the notion of a special relationship existing between a special relationship of invitor-invitee between tavern owners and their patrons. More recently, in 1995, the Supreme Court of Canada revisited this issue in the case of Stewart versus Petty. And in that case, not only did they confirm the duty of care that was set out in Jordan House, but they extended the duty to include not only the patrons who are in their bar, but also they said that it's reasonably foreseeable that a drunk patron is going to go out and injure other people, the motoring public, people using highways. And since that was reasonably foreseeable, they extended the duty to third parties and said, not only do you have a duty towards your drinking patrons, but you also have a duty to keep members of the general public reasonably safe as well. Having established the duty, you have to then look at what is the standard of care, and there are two questions you have to ask. Firstly, in what given circumstances is a tavern going to be required to take positive steps? Our courts are reluctant to tell people that they have to take positive steps. Usually it's acts of commission that negligence are founded upon, not acts of omission. And then secondly, what steps are required to discharge the onus? What the court found was that positive action is only going to be required where it's reasonably foreseeable that intoxicated patrons represent harm to themselves and others. And in the Stewart case, the tavern was able to escape liability on the basis that the intoxicated person was there with his sister and another friend. So in that case, it wasn't foreseeable that the intoxicated patron was going to be the one driving. It was reasonable to assume that he was going to get a ride with one of his sober friends that was with him at the bar. And on that basis, the tavern was able to escape liability. Now, when you're reading that case, I caution you, because that case did not emanate from Ontario. So although it is a Supreme Court of Canada case, the Ontario legislation is, I think that case came out of Saskatchewan. And they don't have the provision section that we have in Section 39 of the Liquor License Act. So there may be a different result here because our Liquor License Act specifically imposes liability for serving a patron to the point of intoxication. Whereas the other, absent that legislation, you see the result that we have here in Petty. And again, the reasonableness of the system of inspection is going to be dependent on the facts of the particular case. And as you review these cases, and I've put a list of 8 cases here. There's 10 reported cases. There's 10 reported cases that I came across. 2 in which zero liability was found. And then we have a range here from 5% in Whitlow versus 572008 Ontario Limited, also known as the Cross-Eyed Bear. And if you read the case, you'll know why the bear was cross-eyed. And then the highest one is Franceschi versus Gilker, 78%. And the facts of that case are interesting. This patron goes into the bar, drinks himself simply into oblivion. He can't walk. He's falling asleep at the table. And he got that way in the tavern. So a kind-hearted employee picks him up, carries him out to his car, places him behind the wheel, and just so he doesn't have a problem, he places his keys on his lap, so that when he does finally come to, he has a way to get home. I mean, it really is ridiculous. And the case was appealed, and the Court of Appeal did dismiss the appeal and upheld the 78% apportionment to the tavern on the basis of a wanton disregard for the safety of the public and of the patrons. I was going to try to get into the pedestrian cases, but I believe I'm out of time, so I ask you to read that. And if you're going to take on one of these tough liability cases, I wish you all the best. Thank you.
Thanks very much, Dale. Our next speaker is Steve Firestone. I don't know if I know anyone that knows more about accident benefits than Steve. Steve, being a member of the bar since 1986, he practices law with Dave Blackman. Steve's on the DAC committee and also the more recently constituted Catastrophic Impairment Advisory Panel, which hopefully is going to do something about the definition of catastrophic impairment. Steve has also written a book, co-authored with Justice Linden on motor vehicle insurance practice. Steve?
Well, I first want to thank the Law Society and John McLeish. When I came in this morning, they told me that all the speakers are getting a TV set, and I thought they went well above Call of Duty in awarding such a nice gift. But thanks, John. I really appreciate it. Has it got a DVD player?
It does.
Oh.
Digital everything, yeah.
I want to talk to you about the accident benefits, the basics that you have to know under Bill 59, and I'm going to be talking to you from a plaintiff's perspective solely. I want to highlight some of the basics in the AB environment that you need to really succeed in these cases, and tell you about some of the important changes vis-a-vis the new guidelines in the DAC system. At the end, I'm going to give you some of the top AB cases that I keep in my back pocket, and I just point out those cases are not in my paper, so you'll want to write some of those down. Just to begin to review the accident benefit entitlements, And I'll go through this very quickly. Regarding income replacement benefits, you'll remember to qualify under Section 4, have to be employed at the day of the accident, or not employed but work within the previous 52 weeks, or entitled to start work under a contract. And you have to have a substantial inability to perform the essential tasks. Regarding the period of the benefit, first 104 weeks, again, substantial inability from your own employment. After the 104-week period, you have to have a complete inability to do the essential tasks of your own employment. Regarding the amount of the benefit, you have to have you get 80% of net weekly income to a maximum of $400 per week. Non-earner benefits, Section 12, $185 a week following a 6-month waiting period. That's new under this legislation. As you know, you get nothing for the first 6 months if the insured suffers a complete inability to carry on a normal life. Caregiver benefits are set out at Section 13. Remember, they're entitled to expenses incurred to a maximum of $250 per week for the first dependent and $50 a week for each additional dependent. And they're payable if a claimant within the first 104 weeks cannot substantially perform the caregiving activities. The student benefits, Section 20, the insurers to pay for lost educational expenses incurred by or on behalf of an injured person, maximum of $15,000 for lost tuition, books, room and board. Medical and rehab benefits, non-catastrophic impairment, you get $100,000, 10 years or 25 years less the claimant's age. Catastrophic impairment, $1 million over the claimant's lifetime. And remember, a treatment plan has to be submitted. If it's rejected, then you have to go to a DAC. Attendant care benefits are at Section 16 of the SABs. Non-catastrophic impairment, $3,000 a month for a 2-year period, and there's $72,000 payable. Catastrophic impairment, maximum of $6,000 a month, and a maximum of $1 million over lifetime. Now let's get to the fun part, DACs. As you know, DACs can clearly make or break your chances of settling an AB case or being successful at arbitration or a trial. I think that the single most important thing that you want to deal with as a plaintiff's lawyer in an AB case. You got to have the tools to attack these DAC reports. Remember, DACs are very different than IE assessments. There are specific rules that are set forth in the SABs and the guidelines, and they have to be followed. You need to make sure as plaintiff's counsel that they are being followed. You got to have the tools to do that. First, you got to know the DAC types. Disability DACs, including post-104 disability DACs, deal with inability to work. Medical and rehabilitation DACs deal with treatment and rehabilitation under the SABs. Attendant care DACs. Catastrophic impairment DACs, which deal with whether or not a catastrophic impairment has been sustained. That is their only function. They don't determine entitlement. They strictly determine, is there a catastrophic impairment? And then we've got the REC DACs under 164. Now, the first tip I want to give you is this. Under the legislation and under the guidelines, your client has to be sent to the closest DAC. That's very different than the IE system that exists in tort. In tort, the defendant lawyer is going to pick the doctor that they know is going to write a favorable report. In the DAC system, they can't do that. They have to go to the closest DAC. There is no DAC shopping that's allowed. Remember Section 53(1) of the SABs. It says, an assessment shall be conducted by the designated assessment center that's nearest the insured person's residence. That key is a word. They have to be authorized to assess the impairment type and authorized to conduct a type of assessment. So you always want to ask, did your client go to the closest DAC, or is the referral being made to the closest DAC? Is that DAC authorized to assess the impairment type, and are they authorized to conduct the assessment type? Now, how do you do that? Well, there's a document that you got to have, and you can get it on FSCO's website. It's called the Roster of Designated Assessment Centers. And if you don't have that document, there's no way you can determine whether or not the insurance adjuster is really pulling a fast one and sending your client to a DAC who happens to have a DAC assessor who also does their IE work. You want to make sure that doesn't happen, and it happens all the time. The Roster of Designated Assessment Centers was released July 99, and it's updated on a regular basis. It tells you each DAC by geographical region, and it tells you exactly what they're authorized to assess and the type of impairment they can assess. Basically, it tells you, are they complying with Section 53(1) of the SABs. The website for FSCO, if you want it, is www.fisco.gov.com. You got to get that roster. Tip number 2, did the DAC follow the referral rules? Effective August 19th, 99, insurers have to use an OCFLA referral form only. That's the only document that they can use. I actually had a case, if you can believe it or not, before the OCF 11A. It was standard for a letter to be sent that some might be called biased. The letter went something like this: we're referring this client to you for a DAC assessment. We think the client is a fraud, a cheat, and no good, Nick. Please send us your objective report. That's exactly the kind of thing that the OCF 11A was meant to stop. But you got to make sure that it's being used properly. It has 3 objectives: to notify the claimant of what the referral questions are, to notify the claimant of the list of documents the insurance company is sending, and to eliminate the need for these bias covering letters. So what do you want to do in each case? You want to ensure that a copy of the OCFLA referral form is being sent before the DAC assessment to your client so you can review it and see if it's right. You want to review the referral form, ensure that there's no biased letters being attached. You want to check the referral questions. Is it a proper referral question? If it's a disability DAC, it's only disability questions that can be asked, not things about treatment, vice versa. But you'd be amazed it happens all the time. You got to check it. And you want to check the documents completed by the insurer. Have they really sent all the documents that are in their possession? Sometimes there's a report that's very, very favorable, and they'll try and hold on to it and not send it, and then it's not included in the DAC assessment. Everything has to be sent. Now let me just tell you about 2 guidelines that have come out very recently that are very important. They have some significant changes. These are in my paper as an appendix at the back. First, we have the new disability assessment guidelines released April 2000. You always want to make sure, did the DAC follow the guideline? If they don't follow the guideline, then the report will be deemed to be invalid or given little weight, which is exactly what you want as a plaintiff's lawyer. They have to be able to do a multidisciplinary assessment. Under the new guidelines, if your client's referred to a DAC, they have to have what's called a core team. They have to have a psychologist, an OT, MSK practitioners, and other physicians. They also have to have access to what's called an on-call team to do a multidisciplinary assessment. And this is the best one, and this is a piece of gold. If you take anything away from what I say today, I think it should be this. In the new guideline, it says they have to have a balanced practice and current practice experience. At page 2-3 of the guideline, I'll read to you what it says, and it is in your materials. The DAC assessor must have a balanced practice in both assessing and treating, and that's the key, assessing and treating patients. To get onto the DAC roster, they have to fill out a certain form that declares what they're doing, and are they doing defense work, plaintiff work, do they actually treat people, or do they only do reports? But you don't want to just rely on that. You don't only want to rely on the fact that, well, they made it to the DAC assessment roster, so they must be objective. What you want to do in cross-examination is put this to them, and there are certain DAC doctors who do a lot of defense IE work, and you want to ask them, do they have a balanced practice? What percentage of their income is made from doing defense IE reports? You'd be amazed, and I suggest to you that there's a number of DAC assessors who would have probably 70-80% of their income coming from doing these defense IE reports. And if that's the case, do they really have a balanced practice? I would suggest not. Want to look at the new MedRehab DAC guidelines. These are brand new. They came out 3 weeks ago, September 15th. They're also in the materials, and this is key as well. Under the guideline, the assessment team can look at proposed, partially completed, or past treatment, or what they call a retrospective review. And they have to do that because by the time a treatment plan is submitted, the treatment may have already been carried out, so the DAC has to have an opportunity to review that treatment. At section 43.6 of the SAPS, they're allowed to make recommendations on the future provision of goods and services. Now that could create a lot of trouble because a DAC could say, well, we think that this client doesn't ever again need any treatment. and they may make a final prognosis in that regard. But again, the guideline says quite clearly that in dealing with the future provisions of goods and services, as it's defined in Section 43.6 of the SABs, they can never say that your client never needs treatment again. They can never say, don't submit another treatment plan, and they can never give a final prognosis. Again, in my practice, I see those kinds of things all the time. You want to watch out for that and make sure it doesn't happen. Another key change that never existed before, in the med rehab environment, if the only issue in dispute is how much the treatment provider is charging for the treatment, then the DAC, at their discretion, can do what's called a paper review, i.e. they don't have to see your client. And the reason for that is obvious. If the only issue is the cost, but the insurer agrees that your client needs the treatment, there's nothing your client could add to that assessment. But they did put in that discretionary provision that allows the DAC to decide whether they're going to see the claimant. So again, you want to check that. I would suggest again that if a DAC insists on seeing a claimant when cost is the only issue, there may be a financial interest, and therefore clearly they may not be as objective as they think they are. Now let me come to these top cases. First case dealing with the role of the DAC. And I put the site up and you can just copy it. Can you see that on the screen? You can just copy it down from the screen. That case stands for the proposition that a DAC assessment is not to be given any more weight than any other report. That's important because obviously adjusters are always saying, ha, 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 this is what our DAC report said. Well, it doesn't work. You got that? What I'll do is I'll print this out and make sure everyone gets a copy after the presentation. That'll be better, I think. Med rehab DACs. This is the key case. This is the best of them all, or one of the best in my opinion. Violian general accident. It was upheld on appeal to the Director of Arbitration September 27, 2000. I think the gentleman who argued the case is in the room. Is he in the room? Because I saw his name on the list. This stands for the proposition that for treatment to be considered reasonable and necessary, it doesn't have to promote recovery. Temporary pain relief is sufficient. One of the most common things that I see is for the defense lawyer or adjuster to say, well, the DAC came back and it says that it's not going to cure your person, it's just going to give temporary pain relief, so therefore it's not reasonable and necessary. Well, this went up to the Director of Arbitrations. This now is clearly the law. For treatment to be reasonable and necessary, I submit temporary pain relief is sufficient. That's a key case that you want to keep. That issue is going to come up on every single med rehab issue in dispute. Disability DACs. When a DAC does a disability assessment, they can't give a prognosis for recovery. Their job is simply to give a snapshot in time, and that's what all the cases say. At the time that your client goes to disability DAC, do they have on that day the substantial inability to do the essential tasks of their employment? Not will they have one 5 years from now, not will they ever be able to work. That's not their role, and they're not allowed to comment on that. Sorry, I didn't give you the case. That's Cook and State Farm. I'll let you write that down. Next one's the DAC referral package. The insurer cannot provide negative one-sided information to a DAC. And that's not really as important now because now we have the new OCF 11A referral form. It's been codified in that form, and that's the Traders General case. The next one deals with DAC neutrality. And this is quite an unbelievable case. I'm sure some of you know it. It stands for the proposition that a DAC can't be an advocate for the insurer. What happened in that case was a certain DAC assessor wrote to the insurer, I quote, "I am writing this report to be of maximal benefit to you when the insured person takes you to mediation." Failed to consider essential tasks of employment. White and Canadian surety in the Rutledge case. DACs have a specific obligation to take steps to find out what the essential tasks of the occupation are. They just can't say it. Objective findings and evidence. These are key cases. Redmond and State Farm and Lopez. Objective findings are not required for there to be an impairment or a disability. That again is a key statement. Subjective findings are enough, just like they are on the tort side. And secondly, the AB and Royal Insurance case is the codification of Athey and Leonetti that exists on the tort side. This is the equivalent of Athey and Leonetti on the AB side. It says that injuries do not have to be the sole cause of the disability. Again, a lack of objective evidence does not disentitle a claimant. I'll get them. They're not in the materials, but I'll get them to you. You can take me out to lunch. I'll get it to you. Malingering credibility. White and Canadian surety. A DAC cannot allege malingering unless they specifically describe the malingering test that they used. And Singh and General Accident, credibility assessments cannot be based solely on demeanor. Those are two important cases. Last case, reasonable expenses. This case says reasonable means not greatly less or more than might be expected. And this is important when you're looking at the test that the DAC is supposed to perform or what their role really is. Their role really is to say, is this treatment within the range of what is reasonable and necessary? Notwithstanding that they may have suggested a different amount of treatments, duration, etc., frequency was appropriate. It's much like a court of appeal. Notwithstanding they would have decided the case differently, they don't overturn it if it's within the range of what's reasonable. And that's really important, because if a DAC report says, well, we think, they need 15 chiro treatments, not more, that's not enough to overturn it or say that it's not reasonable or necessary. Now, I just want to make 2 minutes. A couple of key points. One of my other jobs, I do a little bit of E&O work for the Law Society and some AB claims. And I just want to give you 2 tips that I think will help you. Section 267H21 is an amendment to the Insurance Act that was alluded to earlier. It says that vis-a-vis these collateral benefits, a payment shall not be deemed to be available if you made the application and the application was denied. So 2 tips that I would suggest that you want to do are, number 1, always apply for all acts and benefits. Send in an application, apply for everything, get a denial. Then it can't come back to haunt you in a subsequent tort action. Secondly, if you settle an AB case, you want to get the AB insurer to sign an acknowledgement that you in fact applied for all of the SABs that were available and that they denied it, and then you subsequently settled for less. Then you've done everything to cover yourself with respect to any potential settlement. It can't come back, the tort carrier can't come back and say you would have got more or more was available if you would have applied. You did apply, you got it in writing, and the insurer said they won't pay anymore. Another section you want to keep in mind is section 24(1) of the SABs. It says the insurer shall pay for all reasonable expenses incurred in obtaining a treatment plan. This is the section you can use to get the insurer to pay for your meds. Basically, you'd want the person completing the treatment plan to say that I'm not in a position to complete the plan till I get a vocational or future care cost report. I need that. And they've used it in completing the treatment plan, and therefore I submit the insurer has to pay for it. I have a couple of other points, but I'll leave it for that. The other thing I just want to bring to your attention is there is a DAC complaint process. If you think a DAC is not complying with the guidelines, please make a complaint about them to the Accident Benefit Analysis Unit. I hope that helps. Thanks very much.
Thanks very much, Steve. That was excellent. I'm just trying to think of the best way we can get that extra material to you. And I don't know how many of you are planning to come to the next one, but that is one way we can have it as a handout, those cases and some of those last points mentioned. So I don't know if that'll work for some of you or most of you, but that's one way of doing it. Our next speaker is Terrance Collier. Terry was called to the bar in 1974, practices with the firm of Dutton, Brock, McIntyre, and Collier. Most of you probably know Terry was the winning counsel on the Cugliari case. Terry's going to talk to us about Bill 59, tort rights. This is not Terry here, for those of you that don't know. This is the guy getting him geared up. He's slowly but surely getting used to the computer. Terry? Need help here?
While we're waiting for my colleague Richard Hepner to set this up for me, for which I thank him, I'd also like to extend my appreciation to another colleague of mine, Susan Gunter, who did most of the work in the paper that's in the material. So to the extent that it's good, she takes all the credit, and to the extent there's any problem with it, I take all the responsibility because I vetted it. While we're waiting here, I think this is an opportune time for me to say to Roger, Oatley, and John McLeish what an excellent program that they've been able to put together here. I understand this is part of a series. Having some experience in organizing programs like this in the past, this is quite an undertaking, and they've really done a wonderful job, and they've got an excellent panel of speakers, excluding me. So again, I think that they are owed a lot of appreciation by the profession for the work that they've done here. You all set? Good. Great. Thank you. I'm going to go through Bill 59 fairly quickly in terms of issues that I think are of some significance in a tort context. That requires me to speak from time to time about accident benefits because of the interface between the two systems. The first significant part of Bill 59 with respect to loss of income is the distinction between how one is awarded loss of income for past losses and for future losses. And as most of you probably know, you get 80% of net for losses up to the date of trial or settlement, and 100% of gross thereafter. The purpose of that inclusion was to try to accelerate the process. It's been my experience, I'm doing both plaintiff and defense work now in my practice, it's my experience as a defense lawyer that a lot of plaintiff's lawyers, in my view, are not pushing these cases fast enough. And particularly cases where it's obvious there's going to be a long-term disability, and I think they're costing their clients money, and they indeed may very well be exposing themselves to claims and professional negligence. So my advice is, if you think the case has got a long-term disability exposure, you should move the case as fast as you can. Something that's not dealt with in my paper, but that I was confronted with recently in a plaintiff case I have as a fatality claim. The defense lawyer is arguing to me that he only has to pay 80% of the standard calculation in the fatal claim. As, again, many of you know, the typical dependency ratios that they apply are 70% to a spouse and a single-income family, and then a small percentage, typically 4% of the children. And the argument's being made that they only have to pay 80% of 70%. I think that is wrong. I say that's wrong because the section dealing with loss of income says that payment it says that the damages will be paid for income loss and loss of earning capacity, where damages for loss of income do not exceed or not in excess of 80% of the income loss. Well, the claim for a fatality claim is not in excess of 80% of the income loss, so they can't get, in my view, 80% of 80%. Bill 59 codified the law as it was sort of evolving under the prior legislation about apples from apples. That is, you deduct loss of earning capacity benefits or income replacement benefits from loss of income, med rehab expenses from med rehab expenses, etc. In terms of what they call other expenses, which quite frankly I'm not sure what other expenses mean. They have the same principle of apples from apples, that other expenses are to be deducted from other expenses. The only one that's clear in my view as to what is another expense is the housekeeping and home maintenance. What else fits in that category? Quite frankly, your guess is as good as mine. There was a decision called Brownell and Tannehill, which dealt with the non-income earner benefit. I believe it's section 13 under the SABs, and the question was whether that was to be deducted from non-pecuniary general damages. The motions court judge said no. The divisional court court said yes, and said that if it looks like non-pecuniary general damages, it smells like non-pecuniary general damages, it must be non-pecuniary general damages, and therefore it's deductible because it can't be anything else, which is basically the reasoning of the divisional court. Now that case is being argued, either has just been argued or will be argued very, very shortly in the Court of Appeal. It won't surprise me if that case is reversed in the Court of Appeal. I say that from my experience in Cuglieri. The argument in Cuglieri was that unless it's very clear and unambiguous that something is to be fit within the words of the statute, it should not be relied upon to take away the rights of a victim. And in my view, I don't think it's open for the court to simply say, well, since it doesn't fit into anything else, therefore it must fit into that. I think it has to be clearly delineated to fit into a particular section before it can be deductible. As everyone knows, under all of the no-fault legislation schemes we've had starting in 1990, there were two categories of defendants created. One was called the protected defendant, which is essentially the owner, driver of an automobile or anyone else present at the scene, and then the unprotected defendant, who's everybody else. And that there are different rights and exposures with respect to unprotected defendants. In the area of collateral benefits, it's important to note that the protected defendants have priority in terms of that protection. Loss of earning capacity, this is in follow-up, although it had nothing to do with Cuglieri, because these words came out before the decisions were rendered in Cuglieri. And I'm curious, I would have liked to talk to the drafters of the legislation as to why they did what they did, but under the collateral benefits section dealing with loss of income, under the tort side, they provide for deduction for not only loss of income, but also loss of earning capacity benefits, whereas in SABs, they only provide for deductibility of earnings paid for loss of income. Now, any of you people who have read Cuglieri know that that case really turned on the phrase loss of income, and the court said that CPP benefits were not necessarily a payment for loss of income, but they indeed could be categorized as a payment for loss of earning capacity. So it's my view that under Bill 59, CPP benefits are probably deductible in a tort context, but are not deductible in the accident benefit arena. Finally, future benefits are to be treated by way of a so-called Cox and Carter order, which is that there's an assignment or a trust is created for the benefit of the defendant held by the plaintiff. This is pretty significant, this issue of treatment of future accident benefits. In cases where the claim has a possible exposure in excess of the liability limits of the tortfeasor, there's a lot of pressure put on the tortfeasor's insurer to settle that case because of the assignment of benefits. There really is very little consolation or assistance to a poor insured person who is immediately on the hook for the judgment. And it's not much help to him to know that he's going to be getting $400 a month or something coming in over the next 22 years from an insurer after he's already had to sell his house and his stock portfolio to pay off the judgment. So that's something to keep in mind in terms of some leverage with the liability insurers. Under the dealing with this whole question of the interaction between accident benefits and tort, under the SABs, the benefits are only payable if the incident giving rise to the claim arose directly from the use or operation of a motor vehicle, whereas in a tort context, if the claim arose directly or indirectly from the use or operation of a motor vehicle, you can make a claim. So the fact that they've very consciously used directly and indirectly in the tort side and directly, the word directly only on the accident benefit side suggests that that was done deliberately, and that you may not be getting SABs on one hand, but you can make a tort claim on the other. And there's an example given in the material about having disembarked from a vehicle, and a good example might be getting out of a bus or something like that, and where the bus driver, he stops so that the door is right beside a snowbank, and so the person stepped out, is on the snowbank, and down they go on their butt. And the question then is, can you make a claim for statutory accident benefits? And arguably you may not, but you probably have the right to sue the TTC with respect to in a tort context. I had occasion recently to argue a case dealing with the exposure of an unprotected defendant. And it was a bar liability situation. It was conceded, at least for purposes of this motion, that a bar was, or two bars actually, were 20% responsible for the death of my client and injuries to a couple of other people. And the question was the treatment of the statutory deductible and the liability of the unprotected defendant. The defendant bars were arguing initially that they were only liable for their proportionate share of the deductible, i.e. 20%. In fact, when they made their argument at the motion, they submitted that they were responsible for either nothing or some rather convoluted calculation method of something that always worked out to be less than their proportional share of liability. It was my argument that they are on for all of the deductible. Once they're in for any liability, they pay all of the deductible. And the argument is that as all of you in the room know, under the Negligence Act, it creates joint and several liability on joint tortfeasors, and that if it's a 90-10 split, the plaintiff is allowed to go to the 10% responsible party, collect everything, and then there's rights of indemnity inter se the defendants, but that's an issue between them, and it doesn't affect the rights of the plaintiff. The motions court judge in this case agreed with my argument and found that there was nothing under Bill 59 that restricted the rights under the Negligence Act as against an unprotected defendant. Although that case was addressing really the issue of the statutory deductible only, in my view it applies equally to such things as health care expenses and loss of income, i.e. If an unprotected defendant is on for any degree of liability, they pay 100% of health care expenses. I'm talking about a non-catastrophic case now, where you can't claim it against a protected defendant, and are also on for 100% of gross loss of income to the date of trial. That case, the section, by the way, that was being argued, attempted to be relied upon by the defense bars, and was 267.5.7. The numbers of these sections are mind-boggling now, but in the case that I'm referring to, the Sullivan versus Bond and Birchmount Tavern. It's interesting to note under the prior two no-fault schemes, there was specific sections that restricted the liability of protected defendants to their several liability, i.e. their degree of negligence. And there is no such section under Bill 59. People have talked a little bit about the term catastrophic impairment. That's a magical phrase now under Bill 59 because it creates different remedies and rights under both SABS and tort. In a tort context, you can only claim for health care expenses if you have can establish a catastrophic impairment. And in SABS, there are much heightened access to benefits, which have been touched on in some detail in Stephen Firestone's paper. The term catastrophic impairment is defined in the Insurance Act and the regulations. Some of them are really straightforward and easy. Paraplegia or quadriplegia, amputation, etc., total loss of vision. The subsection E, sub E, the brain impairment with should be GCS, not GSC. That's something I missed when I vetted the paper. Glasgow Coma Scale of 9. Now, it says that, although these words aren't up here, if you read the section, it says that the reading has to be made by a person trained for that purpose. So this Glasgow Coma Scale reading of 9 or less must be done by somebody within a reasonable period of time, and 2, that person must be trained in that particular area. So that raises issues such as if an ambulance attendant has a reading of 8 or 7 or whatever it may be, is that a person that's reasonably trained for the purpose? So that's something that is going to be undoubtedly subject for contest. And the other thing is, and I'm not clear on this as to whether the reading being taken by an ambulance driver, or even indeed the initial reading on the admission to the hospital, for example, in the emergency department, if it's 9 or less, does that mean forevermore that person is treated as being catastrophically impaired, or can you look at the immediate recovery period thereafter? Let's say 2 hours later they take another GCS and the person is now at 15, which is the maximum. Does that mean that the person has been catastrophically impaired for purposes of both statutory accident benefits and SABs? And I think the answer to that question is, I don't know. Also, as part of the definition of the Glasgow, or part of catastrophic impairment, is so-called Glasgow outcome scale. That is, after you have recovered, what is your level after the recovery? And the 2 or 3, I'm telling you, is really bad. That's very few cases where people achieve only a recovery level of 2 or 3. So if somebody's in that category, there is no issue about catastrophic impairment. The next 2 definitions are perhaps the most interesting, and that is 55% impairment of the whole person. That is really a subjective functional measurement of one's level of capacity. And it's important to note that the term is catastrophic impairment, not catastrophic injury. They're looking at function, okay, not the sort of overall effect, but they're really looking at body function, and that's important, and that's really important in terms of this 55% impairment of the whole person. In my material, there's a couple of examples as to how people with multiple impairments and how they do that. You don't simply say you've got 25% with your shoulder and 24% with your leg and 15% with your ankle and add it all together. There's kind of a blending formula that they use. Now the last one is perhaps the most subjective area in terms of catastrophic impairment, and that deals with mental or emotional impairment. And in my paper, I'm going rapid fire here because I know my time is short. It gets into some discussion about mental and behavioral disorders and some of the elements that they look at, and how one might be able to argue that a chronic pain case, that phrase that John seems so concerned about using, you might be able to fit a chronic pain case into the definition of catastrophic impairment. Henderson and Parker. Some of my colleagues seem to be really upset about Henderson and Parker and think that it's an awful decision. I was asked to comment on Henderson and Parker when I was assigned this task as to whether I think it's good law. I've read Henderson and Parker and reread it a number of times to find out why some of my colleagues are so offended by it, and I must confess I don't see why they are so offended. In my view, the sections that were being interpreted by Mr. Justice Heaney in that case are very clear. There's no ambiguity in the language, in my view, at all, that in a non-catastrophic case, health care expenses are not covered. Having gone through this sort of stuff with Collier, I mean, the key is always trying to raise some ambiguity in the language to have a court not apply a particular limiting provision. And I see no ambiguity at all, so unless in the absence of legislative intervention, that will continue to be the law. And last but not least, OHIP subrogation. Under Bill 59, OHIP had no right of subrogation. Bill 164 was silent as to OHIP's right of subrogation, although Section 30, Sub 4 of the Health Act seems to create a right of subrogation for OHIP under Bill 164. And under Bill 59, OHIP indeed does have a right of subrogation. I refer to in the material a case which is sort of interesting, where your rights, does OHIP have the right to subrogate against the Crown agency? Heretofore, or prior to that case, the other Crown agencies would take the place. One Crown agency couldn't sue another, and the court rejected that argument on the basis that it wasn't a Crown agency suing, but it was the injured person, and it was because it was a subrogated right, and their rights were the same as the injured victim. The one Crown agency against the other argument didn't apply. Thank you very much for your time.
Thank you, Terry. That was very good. Our next speaker is Jim Vigmond. Jim was called to the bar in 1983. He practiced defense law on the dark side for a while, saw the light, and now practices plaintiff's personal injury and wrongful death work with Oatley-McLeish. He's current president of Ontario Trial Lawyers Association, doing an excellent job, I might add. And he's going to talk to us, bring us up to speed on the threshold. He's very qualified to do that. He's involved as a co-publisher of something called Practical Strategies, a Threshold Reporter. Ready to go, Jim?
Terry, I understand that there was a companion case to that Henderson, or one that followed it in time and also followed its reasoning, and it's going to the Court of Appeal to decide that issue. So hopefully the Court of Appeal won't find that it was as obvious a case as I understand you to feel it was. And as I must confess, I have some serious misgivings for. My talk is going to be on the threshold, and as you may know, the threshold was introduced when the insurance companies were claiming in 1990 they weren't making enough money, and we then had to have a permanent serious impairment of an important bodily function caused by continuing injury, which is physical in nature. You all say it in your sleeps, no doubt. The legislation was amended for Bill 164, where you don't need a permanent injury, and then it was amended in Bill 59, where it's back to permanent serious of an important bodily function. I'm going to concentrate my remarks today on those decisions which are going to impact on the present practice under Bill 59, and it's important for you to know that there are two significant appellate decisions. This will be very basic to some of you, perhaps not to all of you, but I will elevate it to a different standard as I move through my presentation. The two cases are Meyer and Bright and May and Casola, and you'll want to consider whether we have moved from a tripartite test to a single test, and I'll go through that reasoning in a minute. Meyer and Bright tells us, of course, that the first thing you have to do under the OMPP is determine whether it's a permanent impairment. The second thing you have to do is to consider if the bodily function that is impaired is an important one, and then you get to serious. And really, serious is where all the problems are. I mean, permanent's indefinite. Everything's important but a spleen, and serious is the thing that we really have to become concerned with. Under Bill 59, using the... can I use this? This will work on mine, won't it? Fancy green color here. See if it will work. So is it permanent, is it important, and is it serious? Sequentially in that order. Now, we know that a serious impairment is generally one which causes substantial interference with the ability of the person to do usual daily activities or regular employment. The words that I have italicized are important. Substantial interference doesn't mean a complete truncation. We're looking at a continuum of interference. So somewhere along the line, it is going to be enough of an interference to meet the threshold. Obviously, if you can't work, it's going to be enough. If you can work just as you always did, it's probably not going to be enough. So somewhere within that continuum, your advocacy will help establish that it is serious enough. The court speaks of where there is impairment which frustrates the chosen career path that's serious. Two key words there are frustrate and career path. Frustration, again, means to hinder, thwart, defeat. It doesn't mean to prevent. And a career path, as you'll see later in my talk, includes blue-collar jobs. People may traditionally think of career as meaning lawyers or more white-collar or professional responsibilities. It doesn't take on that context within the threshold. This has been repeated many, many times, but it's helpful to be reminded of it every time defense counsel tries to allege that the threshold is going to bar your claim, and they don't say it nearly as often, I find, as they used to, because it's been so watered down. Fairly, but watered down. Serious relates to the impairment and not the injury. Let's not forget, you don't have to have a catastrophic injury. If it's a small injury, but it has serious implications for your plaintiff, that's enough. Again, there is no justification, according to the Court of Appeal, for saying it has to approach catastrophic. Substantial interference with the ability to perform usual daily activities or frustration with chosen career path, and it's a very subjective analysis, right? So we say this is an insignificant injury to the broader population. Well, we don't care about that. Is it bad with respect to the function of the individual before the court? And forget about the financial impact. I'll go through some cases, or at least I did in my paper, depending on how much time I have. Time and time again, the trial judges have been asked by defense counsel to dismiss a claim as not crossing the threshold because the plaintiff's earning more money than she was at the time of the accident. The plaintiff's in a different job and has now got career advancement. And the Court of Appeal says, no, let's look at where they're going. Let's look at how they've been marginalized. May and Casola is the most important decision under the threshold, not Meyer and Bright. 1988 decision in the Court of Appeal following a 1996 motions court decision of Madam Justice Pardue. The case concerned soft tissue injury resulting in some symptoms of intermittent vertigo, nausea, neck pain, and headache. At the time of the crash in 1991, the plaintiff was a university student and thereafter graduated and went on to work full-time in supply teaching and then part-time when she decided to take maternity leave. But very significantly, she had lost no time from work since the collision, and she had no medications for approximately 2 years before the judge decided the motion, which was probably 4 years before the Court of Appeal heard it. The trial judge says the claim's dismissed. First of all, the injuries didn't substantially interfere with her usual daily activities. It's the usual Mrs. Meyer sort of thing. She can still do some gardening, although less of it, maybe differently. She can still maybe go on her long walks, but less often, and perhaps she has to go on even ground, and things like that. It didn't substantially interfere with her ability to continue employment, full-time or part-time if she chose, but it didn't interfere. There was no time lost from work. The claim didn't meet the threshold. faced with these facts, the Court of Appeal, and this was done on motion, affidavit evidence, Court of Appeal doesn't change any of the facts other than the finding or the legal conclusion, and that is that symptoms having a significant effect on enjoyment of life must be considered as constituting a serious impairment. This, even though it was unchallenged on appeal, that she did not have a substantial interference with her activities of daily living or her ability to work. It's a critical case to have. So therefore, we can say the test is either of two, really. The first is that it is now a serious impairment where a plaintiff suffers substantial interference with their ability to perform their usual daily activities or substantial interference to continue with working, or they suffer a significant effect on his or her enjoyment of life. But in light of the latter, why do you need to really examine the former? I mean, in other words, if it's going to have a significant effect on their enjoyment of life, do you really have to go through all of the steps that is going to be required to convince a court that there's been a substantial interference with the daily activities? I thought I'd take you just through a little analysis of the usual daily activities test, the second prong, or the first prong, if you will, of that three-prong test. Although, again, I don't think it's important for you to use it very much anymore. The court habitually has looked at interference with recreational activities, what sporting things can he or she continue to do, not do differently. They look at socialization. Do they not go out as much? Do they have the same circle of friends or not? Do they stop playing cards? They look at lifestyle. Are they less active than they were before? And they also look at focus of energy. There's lots of cases that say, sure, the person's able to work full time, but they can't do anything else. And the court has acknowledged it's unfair to say a person doesn't cross that threshold because they put all of their energy in work, whereas before they were able to contribute some of that energy to the usual daily activities. The key concept on the employment cases, in my view, is vulnerability. And that is to establish that the impairment that your client suffers from makes them more vulnerable than they were before the accident. And what do I mean by vulnerable? I mean, they're now susceptible to early termination from whatever employer they now have. The employer is less likely to be satisfied with their job performance. There may be higher absenteeism. They may not have the same personality or temperament or get along with others as well. The injured plaintiff is going to be more dependent on the accommodation of the employer. Lots of times we know our clients remain employed because the employer's been their friend or their supervisor won't sort of rat on them, and employers will make accommodation for them, and the cases refer to that. There is employer prejudice. Employers don't like to have higher WCB ratings, higher insurance ratings. They don't like work absences or lack of dependability, so they suffer the vestiges of not getting a job if they ever lose one, and they're less attractive to other people when they market their services. So the courts look at uncertainty of the future. In other words, just because a person can do their job now, the court doesn't end the analysis and say, don't cross the threshold. They say, what uncertainties will they face if they can't do their job? They're at a more competitive disadvantage. You know that concept. They have job restrictions, marginalization. The courts of Mazinski and Clark, the famous case which the Court of Appeal upheld. And by the way, the Court of Appeal has upheld every case on appeal where a person has crossed the threshold at trial, and they have reversed only those where they were found not to pass the threshold at trial, in my review of the cases in any event. Marginalization, a guy with a bad back has a back injury, the guy with a manual laboring job that needs a strong back that doesn't have any education and can't speak English well, suffers a back injury. They're further marginalized. He was bad enough to begin with in terms of employer marketability. Now he's really bad. Reduced productivity, the courts look at. Let me just give you a couple of examples. Erlen Lang was a case where there was no income loss. The guy had returned to work full-time with the same employer, although in a different capacity. The court there said that the employer had tailor-made a position for the plaintiff to accommodate the additional physical disability, and that he had a certain degree of uncertainty in his future, crosses the threshold. He was at a competitive disadvantage because of his present disabilities. Rutherford and Pannunzio, although the guy was an employee of Allstate and the claim should have been dismissed, it wasn't. There was no loss of income. How he got legal counsel, I don't know. He got maximum salary increases post-accident, returned to the same employer, employed in the same capacity, the same hours, and they found there was a substantial interference with his ability to perform his usual and regular job functions. He did the same job, but he just did it differently, and the court, you'll note, uses different terminology, usual and regular job functions, not his regular employment. He still did his regular employment. Finally, with regard to this part of it, NEAM2, this will recognize that you have to take into account part-time jobs. This person could do their full-time job but couldn't do their part-time job, which was 1 shift per week of registered nursing assistant work, and that was found to be serious. I wanted to touch on 2 cases which are similar in a lot of ways but reach a different result, and that is Hupfield and Law and Patterson and Sindel, both recent decisions dealing with people that were employed in the railway. Hupfield and Law, the claim was dismissed after trial, and it seems to me that the court really refused to consider what potential problems this plaintiff was going to face in future. It seems to, in my mind, reject the marginalization concept. That is, this person who was having difficulties at this job is going to have even more difficulties if he goes to another job, given his present infirmities caused by the accident. And the important quote, which I'll juxtapose with the quote in the case which follows, is this: "There is no evidence," the court held, "which would suggest that the injuries sustained in the accident in any way threatened continued employment by the plaintiff at this railway." There was no evidence to indicate that it threatened his continued employment. So let's look at Patterson and Sindel, where the claim crossed the threshold. There was an acknowledgement of the marginalization concept with the court. The courts said, and this is a person who was in a bit of a different job, but because he was having difficulties with his other job and they gave him some advanced position to which he would have aspired had he not been injured. The court there says, also important is his limited education and training. Let's not forget the importance of the facts that have nothing to do with the collision. They are absolutely critical. His limited education and training, and the fact that his already limited field of employment has been further shrunk to an appreciable degree. The economic consequences have been positive rather than negative thus far, but there is no guarantee that his position will remain available indefinitely. These are all referred to in my paper, by the way, and although I don't know that this one is reported, but if anybody needs copies, just send the request to John and I'll get it. So let's look at the difference. Hupfield says there's no evidence to suggest that his continued employment at the railway was threatened. Patterson, given the same facts, says there's no guarantee that his position will remain indefinitely. Is the glass half empty or is the glass half full? One looks at the threat of what might happen in future, the other looks at the threat regarding what the past is. Scarring, these are unpredictable. Let's just make a couple of points. The Meyer-Bright says the court is to consider the extent of the disfigurement, its location, the effect that it has had on the plaintiff and the plaintiff's life, and the Court of Appeal says beyond that they're unable to provide any guidance. Mrs. Dalglish's scar was 15 inches from her breast to the center of her abdomen, but it wouldn't be seen by others. She had no intention of exposing herself. It was not a serious scar, and the case was dismissed. The courts, and again, I review most of the decisions on scarring in my paper. Let me just tell you my summary of when a court is more likely to conclude that a scar is serious. One is the plaintiff has consulted a plastic surgeon. Two, the plaintiff is embarrassed and self-conscious about the scarring. There has to be a sort of a subjective-objective test. It has to be reasonably embarrassed. The plaintiff is female and younger. And the plaintiff has told his or her family doctor that he or she is embarrassed about the scarring, again on reasonable grounds. And the plaintiff has in some manner either altered his or her appearance or dress. A lot of people like these cases of Athey and Alderson, and I really like them. And it's important for the threshold, in addition to the other important things that it stands for. The motor vehicle collision must materially contribute to the impairment So, in other words, it's not the accident in and of itself that has to be constitute a serious impairment. Let's remember Ms. Alderson, who had pre-existing serious problems, who was involved in a motor vehicle collision and was a bit of a punching bag, unfortunately, after the collision, and she'd sustained head injury as a result of a number of concussions. And the Court of Appeal had this to say: in light of Athey, the jury should have been told that if Anderson's overall condition resulted from the cumulative effect of the injuries sustained in the accident, the beatings, and her pre-existing psychological condition, she would nonetheless be entitled to full compensation as long as the jury was satisfied that the injuries sustained in the collision materially contributed to it. The failure to mitigate argument, again, it's in my paper. There's two line of cases. One says that if the failure to mitigate would have resulted in a non-serious injury, they don't cross the threshold. The other case that I've cited says that if they fail to mitigate, it's only relevant to damages. Discoverability is the last concept, John, I promise. This is the case that says you don't have to start an accident within 2 years. On an MPA case, I had a case fairly recently, it was OMPP, where a woman continued to work after the collision. 3 years after the collision, she had twins. 6 months after that, she crashed and burned and couldn't work and required attendant care. And I started my action thinking, why the hell did I do this? And then Pishiro came out. That was great. And we settled it for good money. So don't forget, Pishiro, of course, stands for the proposition that the limitation period doesn't start to run until it's crystallized to some extent where the plaintiff knew or should have known that the injury would constitute a serious impairment within the threshold. And there's a number of cases. There's one where the action was started 6 years after the event, and there was 14 doctors' reports before they could find there was something wrong with the person. And in that case, they allowed the claim to stand, and the court has held that soft tissue injuries were a classic example of a type of injury where time and additional information will be necessary to determine whether the plaintiff's injuries may reasonably meet the threshold. Vigmond's trilogy is Meyer and Bright stands for the proposition you don't need a catastrophic impairment. May and Casola, one's enjoyment of life is all that has to be affected, and Anderson and Callahan says we only need to be a contributing factor. My second trilogy is Sleeman Ale, Lagavulin, and 96 Beaujolais. Thanks very much.
Now the last part of the program, we've called it Tips from the Trenches, and if I could get Terry up here, and Steve and Kim. I missed anyone. Jim's going to stay up, and I don't quite know how to do this. I think what we'll do, we'll start off is this is a very popular aspect of the programs at the Ontario Trial Lawyers Association. I've got some questions that I've discussed with the panel, and we'll start off that way. And if you have questions you put or you want to say something as we go along, put your hand up, and we'll see if we can recognize it. Just go from there. So we've got about half an hour for this. No, just Jim, I've got a question for you, and it's this. Section 258(3), bracket 1, bracket D, of the Insurance Act says that a tort adjuster is entitled to medical examinations before the action is started. Do you see any way of preempting this, such as giving the tort adjuster or giving the defendant notice of your claim, and then racing to issue a statement of claim, so you're now into the lawsuit, into a defense medical, and excluding that Insurance Act examination?
Yeah, John, when we discussed that yesterday, I confessed that I had no examples of that arise in my practice, but know that there are 3 or 4 cases out there, and they seem to reach differing conclusions. The short answer to your question is I almost always issue my claim as soon as I can in any event. First and foremost, because of the problem with the 80% of net versus 100% of gross, and I think I'm negligent if I don't proceed with due dispatch. And second of all, I know that while I want the injury to mature, by the time it goes through the legal process in any event, I will have allowed myself sufficient time for it to mature, and I can always hold it up at the setting it down stage if I want to. But the case law seems to suggest that a Section 258 examination will not preempt a Rule 33 examination, such that, although it's going to the Court of Appeal, I understand the appeal is to be heard this year, that an examination that's requested under Section 258 will not sort of be counted, if you will. The defense is entitled to stacking of its defense medicals according to the tenor of the case law, that they can have a request for a Section 258 exam and at the same time go under Rule 33. So let's say that a physiatrist, Dr. Lacerte, does a Section 258 exam, and the insurer is not happy enough with that, and God knows why not. Then they can go to Dr. Death, and under Rule 33, and Dr. Death can, basically they can ignore the Section 258 exam, which I think just flies in the face of common sense. But I would jump the gun.
Thank you. Terry, the next question is for you. You mentioned to us your case about non-protected defendants being responsible for the full $15,000 and $7,500 deductible. Maybe expand a little bit more. What are the implications for economic losses, healthcare expenses, and how do you see us as plaintiffs' lawyers pursuing claims for 100% of healthcare expenses in non-catastrophic cases with non-protected defendants?
Well, I sort of blew this question here by addressing this in the body of my talk, but I'll repeat myself briefly. The case, again, was addressing statutory deductibles, and the judge found that 1% on the unprotected defendant, they pay all of the deductible. And the reasoning in that case, and indeed there's a paragraph where he makes it very clear that there's, in fact, he says something like there's nothing in the Automobile Rates or Insurance Rate Stability Act, whatever it's called, that impedes the rights under the Negligence Act of a victim against an unprotected defendant. So, and then he goes on to say, in this particular case, that means they pay all the deductible. So that means that all healthcare expenses in non-catastrophic cases are payable by unprotected defendants, and also loss of income is recoverable up to under the normal common law principles, which is 100% of gross. Now, it's important to remember, however, that collateral benefits are available to unprotected defendants, subject to what I said earlier, that there's a sort of a priority with protected defendants, but it certainly enhances your chances of economic recovery if you can bring in an unprotected defendant. So I guess it makes you want to look even more vigorously to try to impose some degree of liability on somebody other than a motorist.
John, can I just comment on that for a sec? That may be one of the most important decisions under Bill 59 ever in however long we have this bill. And Terry, I've read through the legislation by which that issue must be determined, and it's the most convoluted piece of English, Greek, German, Czechoslovakian that I've ever read. Every time I read it, when I'm in a group of lawyers and we hash it out, I've come to the conclusion that it's not worth it for me to sue an unprotected defendant because I have the contrary view. And I suppose I just want to highlight its importance, but I'm wondering if you might be able to shed any light with respect to whether or not the insurance industry sees this as a critical issue, as I think that they should, and whether or not there was any consideration to appealing that ruling.
I don't know whether the insurance industry knows about it yet, but this is sort of, for me, got shades of Cuglieri written all over it. But as most of the people in the audience know, I have a bit of a blended practice, and Cuglieri was a bit of a death knell for me with some of my insurance clients. But in any event, so this might be Cuglieri too, but it is under appeal. I haven't got the notice of appeal yet, but I'm told, because we just argued this a couple of weeks ago, so the section is, he's right, it's very complicated, and it took me a series of readings actually to figure it out, but I think what is most telling is that it's impossible to conclude by putting any numbers. There's no scenario that you can fit into 267.7.1 that would allow you to reach the conclusion that the unprotected defendant is only severally liable to the degree of liability. As I said during the course of my speech, that was sort of the argument that the protected defendants were making, the bars in my case, that they only pay 20%. But what I did in my paper is I pointed out that it was impossible to reach that conclusion, and I went through an example of how I thought it should be interpreted, and to reach the conclusion that I was advocating, that is, they pay all the deductible. And I think that the lawyer for the bar, when he read that over, sort of went back and revisited it and sort of said, holy mackerel, I can't fit my theory into this. So he came up with his own theory B, which was quite interesting. He gave three scenarios: a 20-80 split, that is 20% on the unprotected defendant, 80-20, that is 80 on the unprotected defendant, and 90-10, 90% on the unprotected defendant. And it was only in the 90-10 example that the unprotected defendant paid anything of the deductible.
Right.
Which to me is absolutely absurd. And I emphasized that point to the motions court judge and said, look, if you have to get 90% to get a dime out of the unprotected defendant, that can't be what the legislation intended. Because it just flies in the face, because there's other sections, because it applies not just to deductible, that section, but also to damages. It doesn't say non-pecuniary damages, but damages, that dealing with joint and several liability with other tortfeasors is the heading. And if it's contradictory to that section, the number of which I think is 265, I can't remember, something, the one that says you can't claim, there's no protection for others with respect to health care expenses and loss of income other than protected defendants. Well, that flies right in the face of that. They're getting their protection if you try to put the interpretation on it that was argued by the bar in that case. So as I said earlier about the ambiguity issue in Henderson and Parker, I mean, at the best, that section is ambiguous. From the defense perspective, at the worst, it's clear and unambiguous to reach the conclusion that they pay all. So I should be careful, I suppose, when cases are under appeal about commenting about things publicly, but I'll be surprised if that's changed at the Court of Appeal.
You got a question?
No. They were making the argument about that the business of stabilizing insurance rates, but I think that the answer to that is pretty easy. That it was to stabilize automobile insurance rates, not to stabilize insurance rates for comprehensive general liability insurers. Maybe, but before all the no-fault legislation came into being, I mean, the reason why people were chasing around for people other than motorists in claims was because of inadequacy of insurance coverage. So they were getting screwed then, I suppose, and they're getting no more screwed now. So quite frankly, I don't think that's a very compelling argument.
Let me ask another question here. Kim, this is for you. Section 33, thank you very much, Jim. Section 33 of the SABS says that a no-fault insurer is entitled to a statutory declaration, as we've heard. Number one, here's my questions. Number one, are they entitled to a personal interview? And number two, are there any circumstances under which you would allow the accident benefits insurer to interview your injured plaintiff?
No and no. I don't think you ever have to allow your client, an insured, to meet with the insurance company. The obligation is to provide information, and that is the obligation under the statutory accident benefits schedule. You have to supply information that is reasonably necessary to assist the insurer in adjusting on the claim. And I don't think there is any obligation on the insured person to meet with an adjuster, to give a sworn statement. Yes, you have to provide a statutory declaration if requested, but that's it.
Thank you. I'd now like to ask Steve a question about Section 24 of the statutory accident benefits schedule. Steve, tell us what it says and how it can be utilized for someone representing an injured person.
Well, 24 says again that basically the insurer shall pay for all reasonable expenses incurred in obtaining a treatment plan, medical reports, etc. So again, as I mentioned in my speech, I think there's an opportunity there to get the insurance company to pay for your medical reports or medical information. If you need a medical report or a treatment plan, it's the person who's completing it, you've requested it, and if they write to me and say, look, I'm putting my professional signature here, I can't complete it in good conscience till I see a future care cost report, etc., then to me that's a reasonable expense incurred in properly completing the treatment plan.
Okay, well, let's say that I'm cooking along with both a negligence claim for damages and we're handling the ABs. A couple years have gone by since the collision occurred, and I want to get an updated or maybe the only orthopedic report up to that point in time. So and there's a treating orthopedic surgeon. I've got his consultation reports or his notes up to that point in time. So I write to him and I ask him all sorts of questions, prognosis, diagnosis, things that aren't necessarily relevant to ABs, and I get a bill, say, for $1,200 from him. Is the no fault, and there's nothing at stake for ABs at that point in time, other than, well, there's nothing at stake. What can I do about, if anything, getting the accident benefits insurer to pay for that?
Well, I think you're going to have some trouble. I think it has to be related to Section 24, which is in the SAPs.
Does it?
Sorry, and when you're completing treatment plans, there's two schools of thought. The first one is that you complete a treatment plan, you put everything in way into the future, but that's going to preclude you using Section 24, or that you do it in stages, which is how I do it. But you need to relate it to the AB action, in my opinion.
Does, and just to ask one last question on this, does there have to be an outstanding accident benefits issue, or can you obtain it and expect the accident benefits insurer to pay for it in anticipation of something? Maybe say the 2-year income replacement test is coming up.
Well, if you get the opinion first, and then you subsequently have a treatment plan completed, and the person who completes the treatment plan says, I could not have completed it but for that earlier report, then I think it falls under Section 24.1.
Okay. All right. Now I'd like to talk about case manager. And maybe, Jim, I'll go to you on this one. Let's talk about the appointment of a case manager. The injured person comes into your office. Maybe the accident benefits insurance say it's catastrophic, or maybe it's even not catastrophic, but let's assume it's catastrophic. The insurer is trying to appoint a case manager, or has appointed a case manager, and you don't want that person as case manager, you want someone else. What do you do, and what are your chances of success?
On behalf of the insurer, I fire them. That's what I first do.
And do you have a reason? What's your reason? I mean, you have to have a good reason.
Yeah. We've developed, first of all, I ask whether or not, it depends on what state I get the file at the time that I'm looking at replacing the case manager. I don't, in every case, get a file before a case manager has been appointed. I don't think any of us do. Second of all, I try not to prejudge all case managers, but I do find that because most of them depend on the insurance industry for continued food, that they more generally are inclined to favoring their interests. And sometimes the client has developed a good rapport with a case manager, and the last thing that I want to do is interfere with what is a therapeutic or benevolent or beneficial relationship. But I do have to be a bit proactive and make sure that my client's interests are being attended to, and if they're not, I'll just say to the insurer, even before a dispute may develop, look, we have the right under the legislation to have the case manager of our choice. I don't do it to spite you, but under the circumstances, I would prefer retaining somebody else. And generally, the insurer will agree under those circumstances. Sometimes we have a bit of a cat fight because I'll often want to have one outfit retained, and they'll say anybody but them. And I think that's not an unreasonable approach, and then I'll settle for somebody else. So that's sort of how I work it.
Okay. Thank you, Steve. This is another one for you. You've got a bunch of medical reports in your file, some of which you've obtained for purpose of the negligence claim. There's a DAC arranged for some reason. The DAC writes to you, writes to your client, whoever, and says they want all the meds for purposes of the DAC. What can you do, and what do you do?
This is an important point. It's come up recently. On the tort side, as you know, under Rule 31, during the discovery process, you have to give the findings, opinions, conclusions, etc., with respect to an expert, unless you undertake not to call them at trial. And then under Rule 5303, 90 days before trial, you have to serve that privileged medical legal report. What's happening lately is that DACs are writing and saying, we want a copy of that medical legal report. Notwithstanding that you haven't served it in the tort action, we're basically telling you that you now have to waive privilege, because under the AV process, we're entitled as a DAC to get all the medical reports. That was specifically addressed in the new guideline. And it's in your material, but at page 3-4 of both the disability and the med rehab guideline, it says that the assessment cannot proceed if they're not provided with records to allow an informed assessment. And I can tell you, I'm a member of that DAC committee. When we drafted that, the intention was that the DAC is only entitled to get the minimum amount of records that they need to complete their own independent assessment. They definitely cannot force you to waive privilege. So in my opinion, they're entitled to get the hospital records, and they're not entitled to get anything else. 53.7 of the SAB says that once there's a referral to the DAC, the assessment has to take place within 2 weeks, and that's a statutory right for your insured person, because that's going to prevent your client from ultimately getting to mediation and arbitration if the DAC can keep stalling those assessments because they want to force you to provide the report. So the bottom line is no, you definitely don't have to produce it.
And are there tactical advantages to you as the plaintiff's lawyer in not giving the DAC all the medical reports you have in your file?
Well, I guess there is, because again, when you come to an arbitration or a trial, you're going to want to be able to cross-examine the DAC, and if the DAC did not have all of the medical reports before them, that's an easier way, I guess, to do that.
John, may I just pipe in for a minute? Forgive me, but Steve, what amazes me about DACs, there's very few rules by which they are to be governed. How can they screw up so often? I just got one in last week, and they did their report. They came to their conclusions. They then say, and we received surveillance subsequent to our report being prepared, and we've each reviewed it, and we stand by our original conclusions. She can do more than is disclosed in the surveillance. What can you do when they breach those guidelines like that?
Well, there is, as you know, that surveillance guideline, and it says that they have to have the surveillance before they obviously do the report, and they have to discuss it with the claimant, and that's also in your materials. All I can tell you is, if you get a report like that, to me that's a good thing, because you're going to be able to basically have the arbitrator place no or little weight on that report. So I would actually be happy about that.
But can I just say something on that? But isn't the problem that a lot of insurance companies are influenced by what the DAC says? So yes, at some later stage at an arbitration or litigation, you can attack the findings of the DAC. It certainly doesn't help your client, who now is probably not receiving a benefit in the interim. And, you know, that's what I find working for plaintiffs is so frustrating. What can we do about these DACs now versus waiting until we cross-examine them at some later point? I mean, is there anything, and what? Like, it just leaves a bad feeling.
Well, I mean, I think maybe what you can do, obviously, is educate these adjusters. I mean, again, that case I referred to, the DAC report is not to be given any more weight than any other report. I mean, these insurers seem to think that it's the final word. It clearly, under the SABs, is not the final word. It doesn't determine the issue. It's just another medical report. And the other thing I would do is if the DAC is breaching the guideline, make a complaint to fiscal, because it's then going to be investigated and the DAC's going to be disciplined.
Okay, here's a question for Terry. Notice of intention to sue has got to be given within 120 days. What if the client comes into your office, say it's 6 months, or in any event past 120 days? So notice has not been given. What do you do, if anything, and what do you see as the repercussions?
I don't think the failure to give notice within 120 days means a damn. The fact that there's threshold legislation and that you have to have a serious permanent impairment before you even have a cause of action means, as we know from Jim's review of the Pexiero case, it can be years later that you don't make that determination till. So somebody can say, I didn't know until 315 days later that I thought I might have a serious permanent impairment. So I don't think that's going to have any effect. I mean, that's no bar anyways. It's just simply something that courts can take into account in terms of costs, and I don't think the judges are going to look at that at all. The only thing that's of significance is that until you give your notice, the interest clock doesn't begin to run. So that's the only penalty by late notice. But I don't think it's going to affect the conduct of the action or have any cost implications at the end of the day.
Thanks, Terry. Kim, we didn't discuss this question, so but I'm going to ask anyway. If your client has chosen a case manager with or without your help, but it doesn't matter, it's your case manager in there, do you allow the no-fault adjuster to correspond and communicate directly with number one, the appointed case manager, and number two, the plaintiff's treating physicians and other health professionals?
Well, I find that the case managers a lot of time can be very, very helpful in communicating or being the liaison between the insured and the insurance company, and can a lot of times, through direct communication, get you things for your client that you might not otherwise be able to get. Having said that, though, I always tell the case managers that I want to know before you have the communication, and I want to be copied with anything that goes between the two of you. Second question about ever allowing an insurer, no, never, ever would I allow an insurer adjuster to deal directly with treating healthcare practitioners, particularly doctors. Never.
If I could just add to that, I found in my practice when the insurance company appoints a case manager, rightly or wrongly, the case manager seems to think that they're working and should be reporting to the insurance company as opposed to both sides. So in our practice, if the insurer appoints the case manager, first of all, we try and get them out. And if we can't do that, we definitely will not let them speak to any of the doctors, because really they're performing an adjuster role intentionally or unintentionally.
Steve, just when you try and get them out, do you have some standard excuses that come to mind? For example, well, this is important because it comes up a lot. For example, failure. I mean, they're great at communicating with the insurer, but something like failure to communicate with the injured person, is that one you've got readily handy?
Yeah, you could do that, or Section 17. I'm looking at it now, and it specifically does not speak to who appoints the case manager. So therefore, to me, the implication is this is a good and service that's to be provided to the insured person, so the insured person clearly has the right to decide who they want. And if the insurer happened to get to the mark first and appoint their own, you can get them out. That sometimes works,
yep. And
sometimes it doesn't.
Okay, does anyone have any? There's one question over there, yeah.
What in the event that you tried to get the case manager appointed by the insurer out and the insurer just abjectly refuses to cooperate and they continue to persist with having that person visit your client? What do you do?
Well, then we'll appoint our own and we'll take it to mediation.
Yes.
Yeah, that's a good point. They could revoke the authorization. Yeah.
Yes?
On the issue of protected defendants, what happens in cases where you've got accidents, the tire blows up, you want to go after the manufacturer, the repairman who made the tire and this and that. Are they unprotected defendants and Bill 59 has no application at all? You don't have threshold problems, etc., etc.
Right, because they're not a owner, driver, or person present at the scene, so therefore, because that they characterize that group as protected defendants, and everybody else, by definition, is now an unprotected defendant, and they don't have any of the benefits under the threshold legislation.
You've got the options. Airbag blows up in your face, say, for no reason at all.
Right.
You can either go after GM and have no threshold problems, you're safe.
Right.
Car then, say, goes in, hits another vehicle, you don't have to worry about the other. You don't have to worry about Bill 59 that was threshold.
Yep. None of the limitations apply, in my view. Right.
That's the end of it.
Yeah. As long as you get any degree of negligence on them.
Yeah.
Any degree of negligence.
Right. Okay, back in a second. Yeah, you. Yeah, go ahead.
What are they doing with the multiple accidents, the threshold? When here, person had 3 accidents, they say, well, now it's $45,000 threshold. What's the consensus where they're increasing their dealers?
I know what we're doing, but anyone, Kim, do you have strong feelings
Well,
on
are you
it?
talking about the deductibles and the stacking of the deductibles? I think that's what you're talking about. I looked at that issue a couple of years ago, or a year or so ago, and I had a situation where I had a lady who had 2 Bill 59 accidents, and the insurance companies obviously were telling me, you have a $30,000 deductible on a chronic pain case. You got it. Your damages for non-pecuniary are minimal. And I did an analysis where I think you can make an argument that only one deductible applies. I'd be happy to send you a copy of that paper if you want to give me your email address or your fax number. But essentially, I did come up with an argument where only one deductible does come off. It's kind of a convoluted argument, and I didn't prepare to present it today, but I'd be happy to show you. But just so everybody knows, there is an argument. I don't know if it's going to be successful, but there is an argument to get around that.
Jerry, can I comment on that, John? Jerry, I think what you might argue is that in a multiple accident case, there has to be a global assessment of damages for the 3 accidents, let's say. And then the court, having made that first step, so they say it's $100,000 globally for the 3 accidents, then they apportion it among the 3. So your argument, I think, would be that the deductible is applied against the global assessment of damages. All right? So if you get 100, let's say globally, so you take out 15 for 85, and then the court apportions it among the 85, rather than taking the deductible after they piece it off among the 3. Follow me? You're looking mystified there. Do you follow?
Because you're saying that, first of all, they're global.
Yeah.
Why you just apply one deductible?
Well,
Why?
if you look at the rules for the global assessment, and I can't remember the name of the case, but it's an old case, it says you look at the damages immediately prior to the second accident, okay? So if you look at the damages and you say, okay, damages attributable are X, and you take off the deductible, so say the damages are $30,000, take off the deductible, and all of a sudden it's 15. Then what you do is you look at the damages at the time of trial, global assessment, and they're, say, 100. And the damages attributable to the second tortfeasor are the difference between the damages calculated at trial, 100,000, and the damages payable by the first tortfeasor, 15. It means second tortfeasor pays 100 minus 15. So that, in effect, what happens is the deductible only comes off once. It's very convoluted, but it does work if you follow the logic.
There's no easy answer to it. There's no case law on it. Here's something to think about, and we're dealing with it in our office, is we keep going back to Athey and Leonati and Alderson and Callahan. Say you've got 2 or 3 accidents. To get 100% of your damages based on those 2 cases, you just need one of those accidents has to be a material contributing factor. So you can just sue on one of 2 or 3 accidents on the basis that that collision and those injuries were a materially contributing factor, and be faced with one deductible. Now, in a high-value case, I'm not sure you'd want to do that. But if you're talking a case that's $30,000, $40,000, $50,000, you'd certainly want to consider that. Or if you've got an accident in Ontario and an accident, in Michigan or something where it gets convoluted, the Athy and Leonati and Alderson Callahan said you can get 100% of your damages just from one of those accidents. Something to think about. Alf, for you, where's Alf? Yeah.
It's well good to say get your claim out as fast as you can. What do you do with case management? You're not out your claim, and the next thing you have case management masters breathing down your throat, pounding you out and being on a cross evidence list, and you're going to have to after the accident.
Well, okay, that's a great question, because we, notwithstanding that 1 in 4 cases in Toronto are case managed, we still get our statements of claim issued as soon as possible and served. And we do it for lots of reasons. The defendant might go to Australia, or I just don't want to sit on something and let it maybe miss a limitation period. So we are doing that, knowing, I welcome case management. I love case management. To me, almost without exception, they're pretty reasonable over there, and there are some exceptions, but and you can complicate it further, Alf. If to me, it's not the 55% rule for catastrophic impairment, I believe is going to go the way of the threshold. That is plummet. And that's right now is a 3-year test. Hopefully when they revise the legislation, my spies tell me it's going to be a 2-year test, but I want a shot at catastrophic impairment on the 55% rule, which I can't get for 3 years. And I'll just say for myself, Alf, I haven't had a problem. And I like case management. I have lots of cases in Toronto case management. And I was asking your very question before I got used to it and comfortable with it. I guess should we just take one more? Sure, go ahead.
How do you do a situation where you have a husband and wife come into your office, and the husband is the unique party to the accident? 6 months down the line, you prepare to issue a claim and find out that the wife leaves and have a separation. You all along in 6 months have had both the husband and wife come in, and family, obtain information, and the separation is pretty bitter. Number one, can you carry on in the sense of having a claim issued and naming the wife as the FLA? Or what do? You just tell the other party to go to the council and deal with her rights vis-a-vis the FLA claims? Do you tell your client that you cannot act because you may have gotten, I don't know, maybe you have a situation that happens quite often. I'm talking about the time before the claim is issued, because it happens lots after the claim is issued.
Yeah. Who was driving? Was the husband driving, or?
Let's say the husband was driving and he's the main injured party.
Who wants to go with this one? Stevie, do you feel strongly about it? Or?
We actually had a case like that, very similar, and I hate to say it, but I think it's a conflict. I think it's a conflict, yeah. That's my answer.
Okay, well, I guess that's it. Thank you all very much for coming. I'd like to thank the speakers. Sorry, there's one more thing. There's just one more thing. Jim Vigmond is the president of Ontario Trial Lawyers, and he'd just like to say something for 1 minute. It's hard to shut this guy up, as you can tell.
We have a conference coming up October 26th, 27th. For those of you that want to become members of OATLA, come and see me. And the conference is on neurotrauma. So, thanks.